Appellant of Guerrero and Secretary of State for Home Department.
Mr. Malik.
Ladies, Lord, I appear to the appellant this morning with Mr. Marantonius. Mr. Gallic Casey appears for the Secretary of State with Mr. Nancy.
Yes. Now, before you launch, Mr. Malik, we'd just like some help, as you will have gathered from the emails that were sent out earlier in the week, to which I don't think there's been any response from your side.
Yeah.
But we are concerned about the status of this appeal.
Yes.
And want to be clear in our mind how it's going to be put, and also that your lay client is fully understanding of the potential impact upon him, depending on if we proceed, as you both are asking us to at the moment, and reach one particular decision. So if we're thinking of the issue, effectively ground one, the position, as I understand it, is that you need to lose in order for your lay client to be able to pursue an appeal.
I'm not, it's entirely my fault. I'm not sure if I...
Well, okay. Well, just tell us exactly why this is still an appeal which should be pursued, particularly given that the biometric, that the BRP expired some time ago.
Yes. So in short, our case is that the appellant was granted leave to remain by the Secretary of State.
Yeah.
If we are right, then the appellant had leave to remain until 31st of December 2024.
Yes.
The date that appeared on the BRP.
Yes. So on that basis, he no longer has leave to remain.
No, lady, that isn't entirely accurate. That is because on 23rd of December 2024, before the expiry of the residence permit, he made an application to the Secretary of State for further leave to remain. That application remains pending with the Secretary of State. So if our case is accepted that he was granted leave to remain, then that means that his leave was automatically extended under Section 3C of the Immigration Act 1971, and therefore he has exempt leave. And that, of course, does not feature in the paperwork because...
Well, but is the Secretary of State aware of that? Is that how you understand the case?
Lady, I am aware that he made a further application. I had understood, perhaps I've misunderstood the position. I had understood that application was no longer pending. Quite what the outcome was, I'm not entirely sure. But I had understood it was no longer pending. I know the friend says it's pending.
Is it pending or isn't it?
Yeah, so I took instructions.
And have we got any evidential?
Oh, indeed. So the application was made on 23rd of December 2024.
Sorry, just give me a moment. Sorry, give me that date again.
Yes, 23rd of December 2024. And the appellant enrolled his biometrics in connection with that application on 6th of February 2025.
Yeah.
My instructions, ladies and lord, are that no decision has been made on that application, and that application remains outstanding. That is only one of the many points why this appeal matters. The other point is the point that Secretary of State made in the letter that was sent to court yesterday. This will have real consequence. Of course, one consequence is whether he has pending appeal before the First-Tier Tribunal.
Yes.
So if we are right, then there is no pending appeal because he has leave to remain. If we are wrong, that means that there is a pending appeal that the First-Tier Tribunal will have to decide on merits if the Secretary of State is right. So these are sort of key reasons why there is something in the appeal for sure, and both sides agree that there is.
Yes, wow. That is certainly clearer than it is on the papers, Mr. Malik.
Yes, definitely.
And it
You
would have
may-
been helpful if we'd had a response, as you were requested by my lady.
I take responsibility for that. I do apologise, Milady. I wasn't copied in the email that Milady's clerk sent to Mr. Gully and to the solicitors. So ultimately, the email reached me, but it was only yesterday when there was a follow-up
sorry, you should
email.
have been sent a
I
copy
realised
within-
that there
certainly I
was
asked
an
for
email.
it to go to all council. Never
And
mind.
then there was some discussion, email exchange between the parties, between council, as to how best to respond to that email. And there was an indication that the Secretary of State would write to the court in response to that email.
Well,
So
it wasn't on behalf of both of you. That,
Yeah.
And we should have had a response,
Lady,
even if it was only from yesterday.
absolutely. My apologies. I take responsibility for that. I should have.
Well, the point is, Mr. Malik, it does impact on our preparation of the case, because I think you've been in front of, certainly my lord and myself, often enough to know that we always read very carefully into the papers. And as does my lady, I know she has done in this case from our pre-meeting. And it makes a very considerable difference to our preparation and our ability to get the very best out of the oral submissions. If we're clear what the case is about.
Lady, I do not disagree at all with your observation, but perhaps in fairness to both my instructing solicitors and the GLD, this is a case where, of course, the appellant files a skeleton argument, the Secretary of State then files a skeleton argument, dealing with the appeal on merits.
Well, I think we all know. Anything you want to ask arising out of that? Anything
There's
else?
just one thing. You mentioned earlier an automatic extension.
Yes.
Tell me more about that.
Section 3C of the 1971 Act.
Yes, you'll hear more about this in due course. So there is a provision in the 1971 Act which says that if you make an application for further leave to remain before expiry of your leave, then your leave is automatically extended
Pending the
outcome of the application,
yes.
and if there is a refusal pending the outcome of the appeal. But of course, I may well be wrong about it if the Secretary of State decides that this appellant was never granted leave to remain.
Of course.
One other problem with this, following on from the letter that GLD sent yesterday, is that this morning at around 10 o'clock, the Secretary of State for the first time disclosed minutes of a decision granting leave to remain to the appellant. Granting leave to remain to the appellant. Now, the fact that these minutes were not disclosed earlier, I'm sure was an inadvertent error on part of the Secretary of State. But you do need to look at the decision to grant leave to the appellant. So I have copies of.
Is this the 8th of August decision that wasn't?
This is the decision that was made on 8th of August. Yes. Which
only came to light yesterday or the day before in the light of my lady's questions.
So this should have been surely this should have been before the Upper Tribunal.
Well, it should have been before the FTT, surely.
Yes.
Before only the Secretary of State knew about this decision. The Secretary of State's case, and you'll hear more about this, has always been that there is some sort of system error, and therefore this biometric residence card was just generated by an error. It's not a decision to grant leave. But you now need to put this in the context that there is actually an 8-page decision explaining why this person merits grant of leave, why he is a refugee.
And did they? Was the FTT aware of your? Well, I know obviously the FTT wasn't aware of that,
Yes.
and the minutes that you're going to give us, I understand. But was the FTT aware that you'd made your application?
application for further leave to remain.
Yes.
Prior
Uh,
to the expiry.
the First-Tier Tribunal made the decision on 7th of March 2024,
So it was before the expiry.
before the
Right.
expiry
Okay.
for the application.
Okay. Well, yeah, presumably you want us to
Indeed.
So it's the next step for us to look at
the minutes.
The minutes, granting leave to remain, so granting leave to remain to the appellant. I mean, of course, you'll hear arguments about this as to whether what constitutes a grant of leave, but you do need to see
Well,
this decision.
Do the minutes predate the decision refusing leave?
Yes, indeed. So what appears to have happened is there is no evidence from the Secretary of State as to
We were going to get a statement this morning.
precisely what happened, but what appears to be the case, you hear from that friend, is a change of mind. One decision maker decides to grant leave, the other decision maker decides to refuse leave, and a letter is then issued to the appellant.
I think that's quite right, according to the letter, Mr. Malik.
Oh,
I mean, not that I'm trying to dig the Secretary of State out of this particular hole, which does seem to be quite deep, but a decision was made by a caseworker on the 8th of August, but then it was reconsidered.
So there's no.
I don't think it didn't feel like it was.
There's-
Mr. Gullick will correct me if I'm wrong, but it doesn't feel like there were two parallel decisions. It's like one decision was looked at again, presumably for.
Yes. So it matters not for the purpose of the argument that I pursue, but this, with respect, is an extraordinary state of affairs. I mean, this should have been in evidence. So if the Secretary of State's case is that there was a decision which was then reconsidered, there should have been some evidence before the First-Tier Tribunal and the Upper Tribunal that there was a decision and then it was reconsidered, not that it was a system error, as the Secretary of State said.
Was the there isn't a chronology.
And of course, so you'll hear more about the chronology, about what
Yeah, well,
happened.
there should be a chronology.
Yes.
There isn't. Okay. Let's, Mr. Gullick, I presume thank you for now disclosing the minutes once you became aware of them.
Yes.
And I presume you'd like us to look at them now.
Well, no, I can't object to you looking at them. I do object to learned friend's description of them as a granted leave to remain.
Understood.
But the position, well, I can say no more than the position set out in GLD's letter, which is that
The letter promised a witness statement. Do we have the witness statement?
nor not yet. It is being worked on. I'm sure those
And
behind.
will that explain such matters as how if this came to be described as a system error and what was meant by that?
Well, Lord, those behind me have heard your lordship's question.
I would like, Mr. Gullick, I would like us to be given the minutes, and then we'll take them, and actually we're going to rise for a few minutes and we'll just read them and just take stock ourselves about what actually is happening, and when you could perhaps take some instructions as to when a statement will be ready.
Ladies, my lord, indeed, I have no issue with that, but I would ask the court to decide the appeal on the papers that are before the court. I mean, it wouldn't be appropriate to, of course, it's entirely a matter for the court, but if there is new evidence from the Secretary of State, then, I mean, it has to pass the Land-Marshall test. I mean, why this evidence is being adduced now, why it couldn't be adduced with due diligence before the tribunal below.
But you've asked us to read it.
This for sure,
Yes.
that's uncontroversial, but a new
So
evidence.
you effectively are accepting that that's evidence that should be
This
adduced.
this surely you should look at it. But if the Secretary of State now adduces evidence
I see what you mean in the form of a
explaining
statement.
what has happened, then
Understood.
that will seriously.
You are
prejudice-
distinguishing between disclosure.
Understood.
This is late disclosure.
This is disclosure, not evidence.
As
yes.
opposed to, yeah, perfectly understand that.
Lords, the Secretary of State's proposed witness statement is to assist the court in connection with the issue that's arisen following my Lady Justice May's question to the parties. As the court will have appreciated from the letter that GLD sent, that prompted research which uncovered what has been now provided.
Yes.
That has been disclosed. Secretary of State doesn't seek to positively rely on it, and indeed the Secretary of State's position is that this material is not
Is effectively irrelevant.
is irrelevant.
Yes,
indeed, in
because
terms of
what
the
matters is whether the BRP granted indefinite leave to remain or not.
Yes, and the Secretary of State's position is this material does not affect the outcome of this appeal at
Understood.
all.
Well,
But the Secretary of State has disclosed it because the Secretary of State recognises it ought to be disclosed as a result, because necessarily these matters have been discovered following my lady's question. So it's not a question of a Ladin Marshall statement, Secretary of State. It's a question of explaining the position. If the court
You've
wants
asked
one, then
Yep.
the court will have to have one, a witness statement.
if someone, while we're looking at it, Mr. Malik, and having a brief discussion outside court, if someone could tell me, and if it's in the papers, the date's not stuck in my mind, when the BRP was sent out.
I think it was the 17th of August.
I know it was August.
Well, my lady can see on page 129, the BRP itself is said to have been issued on the 17th of August
Right.
on the BRP.
Right. I just was trying to fit in where the 8th of August, the issue of the BRP and the refusal, how it all fits together. Right. If we could have those passed up, please. And then we'll just rise for a moment. Thank you.
Ladies, no, before you rise, may I make it absolutely clear that I do not seek to criticize for a minute either Millennium Friends or those who sit behind Millennium Friend. Indeed, we are grateful for this late disclosure.
Yeah, well, thank you, Mr. Malik. I mean, I didn't think you were. I didn't think you would. Thank you.
Court rise the table.
In terms of your, maybe the simpler issue, the outstanding application for leave to remain, I'm told, although your solicitor will have it, they were written to in March this year after a complaint to say it had been voided on the basis that he had an outstanding protection appeal in the First-Tier Tribunal, according, of course, to the Upper Tribunal.
pending appeal. sorry, he has a pending appeal.
Pending appeal in the First-Tier
in the
Tribunal.
First-Tier Tribunal. So, what I mean, it all really comes down to, boils down to whether, but it is perhaps at least arguable. I mean, if I'm right, then there is Section 3CD.
Well,
if
I
I'm
mean,
not,
it
then
doesn't matter.
it
I
doesn't
mean,
matter.
in terms of, I mean, I'm not saying there's no consequence to this appeal. So
Yeah.
whether the consequence is what you say, whether the consequence is what
what I
I
say,
say, it doesn't really matter. There is a consequence to it,
Yeah.
and they're not necessarily concerned with the consequence.
If a decision is voided, the application is rejected as invalid, then is there a decision that the Home Office produces saying that, well, your application is invalid? And if there is one, then we haven't seen it.
Exactly.
Yeah. So I'm sure you've asked for a decision, but there is none. You know, I've checked and double checked.
No,
It's
the
just-
actual
yeah.
decision. There we are.
But it matters not.
She's looking for
I'm not sure what she meant when she said that you have to lose on ground one
I didn't understand
to
either.
pursue the appeal. What does that mean?
I think to pursue the protection appeal in the FTT, you have to lose on ground one.
How?
I don't understand. No, I don't understand either. No, I didn't understand either.
I want to visit that. They found that thing that they're diligent. And that's the last time we had to explain what Section 3 is.
rise the table.
Thank you, Mr. Malik. We've Ms. Garrett, we've had an opportunity of reading that. Now it's thrown up another question, and this is something that we're concerned about from your lay client's point of view. There is the issue which you're subject to your appeal about whether a BRP simply issued in the way that system error does or does not grant leave, and put that in a box, and that's something that you may succeed on or you may not succeed upon. What we are concerned about now that we've had this document and know that the BRP was issued was that on the facts, even if we decided that ordinarily on its own the issue of a BRP does not serve to grant either temporary or permanent leave to remain, in certain circumstances it could be that you would persuade the court that on the facts of your case, regardless of whether ordinarily it does or does, freestanding, if I can put it like that, it would serve to have granted your lay client the leave.
Yes.
On the facts of this case, it did.
Yes.
Right? So we are very concerned about potential prejudice to your lay client's appeal as the factual understanding of what's gone on stand at present. Because what we don't know, and I'm confident neither Mr. Gullick nor his junior nor his instructing solicitor currently know, is this what happened with this document. So, for example, if this document, which weirdly purports to grant you 5 years expiring in 2023, and it's dated August, but we don't know what happened with this document on the 8th of August. If what happened on the 8th of August, because we don't know how the system works, if that then was sent by a computer onto the next person with a view to then that decision having been made, that the BRP was then to be issued, yes, and was in fact issued, and in other words, and that the reconsideration, if we can just call that, I know you don't call it that, I'm calling it just for ease at the moment, on the 11th of August didn't catch up with it, then you, I'm confident, would be submitting to us that regardless of how ordinarily a BRP simply issued in error might be regarded, that on the facts of this case, a decision was made on the 8th to grant your lay client leave, and it was activated, and you were sent the BRP confirming that, and that therefore that your lay client had indeed got indefinite leave, and therefore your further application and so on and so forth that you were telling about earlier. So, Mr. Malik, we are concerned about the justice to your lay client of proceeding today with the appeal. Now, I'm not talking about putting stuff off for months or anything like that, but it's because of our concern for the position you've been and your legal team have inadvertently been put, and our lack of understanding of what's happened and potential impact on your lay client's appeal, which of course is the utmost importance to him.
Yes.
That we now would like us all to consider together whether or not we need to adjourn in order for us to get some proper detailed evidence about all of those issues.
Can I contribute to that consideration, lady?
Please do, Mr. Cullen.
There is a witness statement which I have been just sent, which I've been reading whilst listening, of course, to your ladyship as well, multitasking.
Even though you're a man.
Yes, lady. The content of that witness statement addresses several of the points that you've made to my learned friend. My learned friend won't have seen it yet, so I'm not going to read it out, and the court may wish to see it as well. I can say it doesn't address squarely the point my Lord Justice Arnold made just now.
Well, you see, what is particularly troubling us is this still unanswered question, which was raised as long ago as the hearing before the FTT, as to how it came about that the BRP was issued in error, supposedly. Because one hypothesis, and I emphasize it's a hypothesis, is that the BRP was issued in response to this document, which we have just seen today for the first time. In which case, it could be argued, I express no view one way or the other, but the argument would be open that even on your analysis of the law, as set out in your skeleton argument, that's a perfectly valid grant. Now, I'm not expressing one view or another, but I think you will understand why we are concerned that there are potentially facts that might be relevant, which we don't yet know.
Fully understand my lord's concern.
And also that Mr. Malik must have an opportunity to consider.
Yes, I fully accept that he must have an opportunity to consider such material as he needs to in order to properly put his client's case. And it's a matter for, of course, my own friend how he wants to put that case. But the question, I think, some of the questions that have been put from the bench may be answered or at least addressed by the witness statement, which and I wonder how it might then conveniently be sent to the court, because of course we don't have a printer here.
No,
so
no, no.
It have to be emailed.
Well, it would need to go
we
through
have the
to
email
my,
addresses, of course.
it would need to go through to my clerk, who would print out copies. But does it? Can you tell us from your brief reading of the document, does it address the question of whether or not the BRP was sent out consequent upon this document?
Yes, it does.
It does. And what's the answer?
Well, I don't want to misquote it. That the BRP was automatically generated as a result of the decision of the 8th of August. The error was identified and subsequently corrected.
Ladies, Lord, I do not require further time. I'm content to proceed on that basis. Indeed, the First-Tier Tribunal found that on the facts of this case, the appellant was granted leave to remain. And all I'm asking this court to do is to say that there was no error of law in that decision, and that decision stands.
We better see this statement.
It's longer than the paragraph I've just addressed.
No, obviously. Now, what?
Yeah, I mean, we need to read the statement.
Yes, we do need to.
Yeah.
Can you help me on this? Because one thing we haven't yet discussed, because we haven't got to that point in the appeal yet, but was a question that was inevitably going to rise in the context of the appeal on ground 2, is why, if the BRP was issued in error, it was not cancelled or revoked. Does the witness statement explain that?
Not I think, in the detail that my lord's question perhaps indicates my lord would require.
Well, it's a question again, which was raised along ago as the FTT.
Lord, it indicates that the BRP was cancelled on the Home Office's systems. I think it must be common ground, because no one's suggesting that the appellant ever received a letter saying your BRP has been cancelled until the letter of the 16th of November 2023.
But that didn't say it was cancelled.
Well, sorry, it was issued in error. It didn't
say it was cancelled.
Well, depends whether my lord thinks that what is required is a statement that it is cancelled in circumstances where it was issued erroneously.
Well, that's perhaps a matter for argument if it arises.
Perhaps it is. I mean, of course, the focus has been on ground 2 for understandable reasons, but you only get to ground 2 if I'm wrong on ground 1, and it may be that the court has a provisional view on ground 1. But ground one is that the Secretary of State had no right of appeal from the First-Tier Tribunal's ruling to the Upper
Sure,
Tribunal.
that's an independent question. We understand that.
Yes, but that is, it would have been, it isn't possible, in my respect, submission, for us to simply park that argument to one side and simply focus on ground two, because it is a question of jurisdiction.
Oh, absolutely.
No, we understand.
But nevertheless, I mean, at this stage, we don't know what the court is going to decide
Yes,
on ground one.
Yes.
So we have to contemplate what the consequences are, looking at it in both possibilities.
I get that. I mean, it's just that in the interest of sort of saving the court's time, again, entirely a matter for the court, but it may be that the court would want us to start making submissions on ground one.
Yes,
while
no,
the
absolutely.
petition while the statement is being printed
All right.
and brought to
Yes, I think
the court or
so.
emailed
Yes.
to the court.
Yeah, I think that's very sensible, Mr. Malik. Yes, let's do that. Let's.
Would you like it by email, maybe?
I think if you send it to my clerk by email.
I think we
and-
have the details of all three clerks, because I think they were CC'd into
They were.
Justice May's clerk's
were.
email.
And if we can just
I mean-
ask, I'll ask my clerk to bring three
Three
hard copies
copies, yeah.
through. But Mr. Malik, would it be helpful for you to have a hard copy
Clearly,
also?
I know Mr. Malik's got to have it, and it's got to be emailed to his solicitors as well.
Yes, yes. If Appellant is those instructing it are able to email it to me directly into my junior.
Right.
So
Just give me one moment while I just ask.
So, lady, the first question is whether the Secretary of State had a right of appeal to the Upper Tribunal from the First-Tier Tribunal's ruling that the appeal has been abandoned by the reason of grant of leave to remain. Ladies and lords, you have seen the First-Tier Tribunal's ruling. It is at page 89 of the bundle. The ruling says at the outset that it is a decision on the validity of appeal, and the tribunal is deciding a preliminary issue. This is page 89 of the bundle.
Yeah, and the phraseology of preliminary issue is repeated in paragraph 6
Indeed.
and again in paragraph 28.
Indeed.
So it's a decision on a preliminary issue.
Yes.
Does that mean it's a preliminary decision?
That is a question for the court. Yes. So that really is the question. So in order to resolve that question and consider whether there is or there isn't a right of appeal, my ladies and lords, we need to look at the underlying statutory provisions. In the authorities bundle, behind tab 6.
Just before we get into the detail, this authorities bundle is unique in my experience because the cases are in reverse chronological order. I've come across chronological, I've come across alphabetical, I've even come across random. But reverse chronological is a new one on me.
CV.
Sorry?
It's like a CV.
Is there some reason for that?
Well, there is a document. No, there isn't a reason there.
All right.
There is a document on the court's website suggesting that chronological order is a helpful order.
Chronological is helpful, yes. Reverse chronological, less so.
Let's take the point.
In any event, it's got tabs on, so I'm very Thank you,
So-
Mr. Malik.
tab 6 of the bundle.
Yes, thank you.
You have section 104. So in order to decide whether the ruling was a preliminary decision or a procedural decision, and of course it is for the court to decide what is it that the first-tier tribunal was deciding. So the first-tier tribunal was deciding whether the appeal has been abandoned under section 104(1)(b). And ladies and my lord will see that that subsection creates a distinction between a final determination of the appeal and the appeal being withdrawn or abandoned. So the statute, the Parliament has made a distinction between final determination of an appeal or another type of disposal, namely by withdrawal or automatic abandonment. And you will see from subsection 2 that the appeal is not finally determined as long as it is pending either with the tribunals or with indeed with this court. But subsection 4a says that if a person who is in the United Kingdom is granted leave to remain, then the appeal shall be treated as abandoned. So the task of the first-tier tribunal was to decide as a preliminary issue whether there is leave to remain, which meant that as a matter of law, the appeal is treated as abandoned.
So 4A is a deeming provision. That may not be significant, but that seems to be what it is.
It is a deeming provision, yes. And it has no element of discretion. An appeal must be treated as abandoned if there is granted leave. If you then go to tab 3 of the authorities bundle, you'll see section 11 of the Tribunals Courts Enforcement Act 2007. And ladies, my lord, will see that there is a right of appeal to the Upper Tribunal, not on facts, but only on a point of law. Only on a point of law, from a decision made by the First-Tier Tribunal. But that right is limited to a decision that is not an excluded decision, other than an excluded decision. What is it that excluded decision means is dealt with at subsection 5. Says that for the purposes of this subsection, an excluded decision is, and you will then see a list of the sort of decisions that are considered to be excluded. But for the relevant purpose, it is subparagraph 5, subsection 5F that is relevant. Any decision of the First-Tier Tribunal that is of a description specified in an order made by the Lord Chancellor. Parliament identified certain excluded decisions and then left it to the discretion of the Lord Chancellor to specify by order any other decisions that Lord Chancellor felt ought not to be subject of an appeal to the Upper Tribunal. The Lord Chancellor exercised the power under subsection 5F and made the order that you have behind tab 1. This is the Appeals Excluded Decisions Order 2009. And you'll see that paragraph 2 says that for purposes of section 11(1) of the 2007 Act, the following decisions of the First-Tier Tribunal are excluded decisions. You'll then see a list and
Sorry, where are we now?
this is the next page, page 5. You'll see paragraph 3. You'll see a list of decisions that the Lord Chancellor says are excluded decisions.
Yeah.
And then on page 6, you have subparagraph M, which is key to this appeal: any procedural, ancillary, or preliminary decision made in relation to an appeal against a decision under Section 82 of the 2002 Act. The question is whether the First-Tier Tribunal's ruling, which the First-Tier Tribunal said dealt with a preliminary decision, a preliminary issue which was a preliminary decision, was as a matter of law either a procedural, ancillary, or preliminary decision.
So, in your submission, what is the policy or rationale for excluding procedural, ancillary, or preliminary decisions?
My submission, which is supported by the authorities, is that Lord Chancellor felt that it is only substantive final decisions that ought to be subject of a right of appeal to the Upper Tribunal.
Do you link that back with the words finally determined in
Precisely.
section 1041B?
Yes, so that is the context in which, in my submission, ladies and Lord will consider the statutory scheme. And this applies to appeals from the Upper Tribunal to this court too. So if the Upper Tribunal makes a sort of substantive decision, final decision, there is an appeal to this court. But if the Upper Tribunal knocks out an application for permission to appeal on the basis that it isn't arguable, the Upper Tribunal decides that an appeal is out of time, there is no valid appeal before the Upper Tribunal, there is no right of appeal to this court, precisely for the reasons of this order. There isn't, I'm afraid, much case law on the subject. Two authorities that would assist. The first is the judgment of this court in a case called Singh. Singh is tab 18 of this bundle. When the First-Tier Tribunal decides an appeal, it also decides whether to make a fee award. Fee award is an award that requires the Secretary of State to refund the tribunal's fee that an appellant pays to the tribunal to pursue the appeal. And the issue before this court in Singh was whether that decision is appealable. If you go to page 283 of the bundle, you'll see paragraph 19. It does not, of course, I accept, answer the point that I'm seeking to make, but it will tell you something in my respective submission as to the scheme of section 15(5)(f).
Would you like us to read that, paragraph 19?
The text that appears between letters C and D. It is obvious from the language of section 11(5)(f). And then paragraph 20, just below letter E. That does not mean that the costs decision, the fee decision, is part of the substantive decision on merits. Substantive decision on merits. The court there is making a distinction between a substantive decision on merits and something that isn't a substantive decision. and then says that as a matter of ordinary language, it is obviously ancillary to it. So there is a distinction between a substantive decision and something that isn't. Something that is separate but connected matter which requires to be determined to dispose of the proceedings. So not that it answers the point, but it is an authority in my submission from the proposition that the statute makes a distinction between substantive decision on merits and decisions that are not substantive decision on merits but are somehow connected with that task. It is only the substantive decision that is appealable. Those decisions that are not substantive but relate to a connected matter are not. The second and final authority in the subject is the decision of this court in DJ, Pakistan. DJ is tab 12 of the authorities bundle. And this actually tells us in my submission what preliminary, procedural, and ancillary decisions are. The paragraph that tells us what those decisions are is paragraph 33, page 193 of the bundle. So if you look at that paragraph, you see that the court quotes from the Upper Tribunal's reported decision, which is then endorsed by this court and was endorsed by this court again in two other judgments. But you'll see that it is said just above letter G, a decision is procedural because they are part of the statutory procedure prescribed by section 12 and do not finally determine the merits of the appeal. So here, the First-Tier Tribunal made a ruling that was part of the statutory procedure prescribed by section 104. And it did not finally determine the merits of the appeal. Hence, the FTT's ruling was a procedural decision. They are ancillary because they provide necessary support to the prime task of deciding the appeal under section 11. It is connected to the central and ultimate task of the Upper Tribunal. The First-Tier Tribunal's ruling provides, in this case, provides necessary support to the prime task of deciding the appeal. So if the First-Tier Tribunal had decided that there is no grant of leave, it would then have proceeded to decide the appeal on merits. So the decision is connected with a potential substantive decision, and the exercise provides necessary support to the prime task of deciding the appeal. And then a preliminary decision is one that is made at an early rather than late stage of the process, necessarily preceding the performance of the ultimate task. Here, it's a preliminary decision because it was made at an early stage. It preceded the performance of the ultimate task of deciding the appeal on merits.
Mr. Malik, this part that you're taking to us is actually a quote from what the Upper Tribunal said, which of course was subject to the appeal. Can you take us to the part of the judgment that then where it's either accepted or clarified or?
Yes. So this judgment has been, BOM, the Upper Tribunal's judgment has been endorsed on 3 separate occasions by this court. So if you look at the next paragraph, paragraph 34, you'll see that in Tezagahi, this court referred with approval the Upper Tribunal's judgment in BOM, the judgment that is cited.
Right.
And then you'll see that there is, within that judgment, he cites, Lord Justice Dingyman cite paragraph 30 of A.A. A.A. is the other judgment where VOM was endorsed, and this is the third time there is an endorsement of that decision, because that paragraph ends with saying that I respectfully agree. So if you apply this formula, this formulation, then in my respective submission, First-Tier Tribunal's ruling is either a procedural decision or a preliminary decision or an ancillary decision. And that really is ground one. If I'm right about this, then that means that the First-Tier Tribunal's ruling stands. The Upper Tribunal had no jurisdiction to interfere with that ruling. You may, of course, ask a question that it would be a rather unsatisfactory state of legislation if the First-Tier Tribunal makes a decision that isn't in accordance with law and there is no court or tribunal that can do anything about it. That isn't the effect of my submission. If a party wishes to challenge an excluded decision of the Upper Tribunal, the remedy is judicial review. There are judicial review claims all the time directed to such decisions. There are examples in the authorities bundle. I will not take you to a case called Chowdhury that is in the authorities bundle, where an excluded decision is challenged successfully by way of judicial review. So the remedy for the Secretary of State was judicial review, not an appeal. That takes me to one final argument that Valentin has made in answer to this point. And that is in his skeleton argument at paragraph 24, which is page 8 of the hearing bundle.
Sorry, paragraph.
Paragraph 8. So Valentin says that, well, assume that there is no right of appeal. So page 24 of the bundle, paragraph 24 of Valentin's skeleton argument.
On page 10.
My
Page
apologies,
8.
My apologies. So it's page 24, paragraph 24.
Yeah.
So Valentin says that, well, if there is no appellate jurisdiction, then this court should sit as a divisional court of the King's Bench Division and make a decision. And Valentin cites two authorities for that proposition. That, with respect, is a bad point, and Valentin, I'm sure on reflection, will not pursue it. The reason being that divisional court no longer has jurisdiction over the First-Tier Tribunal's excluded decisions. The divisional court, the High Court, has no supervisory jurisdiction over the First-Tier Tribunal. With effect from 17th of October 2024, the supervisory jurisdiction that the High Court previously exercised was transferred to the Upper Tribunal. The court, of course, knows that it is the Upper Tribunal that deals with immigration judicial review now. The court cannot possibly sit as a divisional court without any pleadings. Yeah, I mean, if you keep all of the difficulties to one side and to grant relief that the Secretary of State seeks. And that, therefore, is a bad point. And these are, in short, my submissions on ground one. If I'm right on this ground, then the court need not to deal with ground two. The court will simply conclude that the First-Tier Tribunal's ruling, which hasn't been challenged by way of judicial review, stands, and that is the end of the matter. So these are my submissions on ground one.
Can I just ask one more question on ground one? You've addressed us on the policy or rationale for the exclusion in paragraph N. Do you have anything to say about the more general proposition that one should be hesitant about excluding rights of appeal in the absence of clear ones.
Well, my there are two ways that I will answer the point. The first being is that the statute here is clear. It couldn't be clearer. It makes a distinction between substantive final determination and preliminary procedural and ancillary decision. It says expressly that an excluded decision isn't appealable. Section 11 says that there is a right of appeal other than a
Sorry,
decision.
where does it make the distinction between the final decision,
So,
as you've just said? How does it do that?
so if one looks at Section 104 of the 2002 Act, so Parliament creates a distinction between final determination of appeals and other disposal of appeals. So Section 104 says, well, the appeal uses the phrase, the appeal is finally determined,
Yeah.
withdrawn, or abandoned. So Parliament makes that distinction in a different statute, I accept, but which is connected to the statute that we are looking at. You then have jurisprudence, the two authorities that I've taken you to, making a distinction between a substantive final decision on merits and the decisions that are not. So the statute, I say with respect, is clear. The second point is that this isn't, that the court isn't dealing with a provision that restricts access to justice. And there are provisions, the court knows, whereby judicial review is excluded, judicial review is restricted. So if the Upper Tribunal refuses permission to appeal, judicial review is not available, unless an exception is met. So where the issue before the court is access to justice, the court, as my Lord Solomon said, has said repeatedly that the statutory provisions should be scrutinized as rigorously as possible, and the court should proceed on the basis that Parliament's intention isn't to restrict access to justice unless it is done by clear statutory language. This, in my submission, is slightly different in the sense that there is a mechanism of challenging the decisions by way of an appeal. So when Parliament enacted Section 11, when Lord Chancellor made the 2000 order, they knew that there is a way to challenge such decisions, namely by way of judicial review.
So in your submission, there's therefore no need to give Article 3M a narrow interpretation. You say it should just be interpreted in accordance with the ordinary meaning of the words. Okay.
Well, I'm either right about this or wrong about this, and it's really a matter for the court to decide what these words actually mean. What the Upper Tribunal has said with respect, in my submission, makes little difference, because it's really a question of law for the court to decide. So these really are my submissions on ground one.
Thank you, that's most helpful.
So subject to any observations, now make submissions on ground two. I may need a minute or so just to quickly look at the witness statement.
Yes, well, the last I heard is that it hadn't arrived, certainly with my clerk. I don't know if it's, isn't it? Just come. It's got, and they're bringing through the witness statements to us now. So you need, do you want us to rise for a few minutes so you can actually absorb what it says and discuss it with your team?
I'll be very grateful, yes, indeed, and it may give ladies and Lord an opportunity.
And we'll be getting copies as well. So shall we say 5-2? That gives everyone time to have a look.
Court rise in favour.
5 days. Best to avoid dealing with the fever.
if you're right about this point about the divisional courts, then it creates a sort of never-ending procedural loop, doesn't it?
In what way?
Because on that basis, then what should have happened in the Upper Tribunal is that they should have reconstituted themselves as a judicial.
Yeah.
Yes.
And decided it's why we have judicial review. Yes, but the question is whether this court can now, this court cannot sit as a divisional court of grant relief, and there is, and you may disagree.
Well, let's have a think about that.
Yeah, and then so there isn't a sort of parallel provision that allows the Court of Appeal to sit.
They could sit as an Upper Tribunal, but then of course there would be an appeal to the Court of Appeal for their decision,
Yes, but
as there would be from the divisional court.
No, there is then a problem. Do you remember a judgment, NB Algeria, which discussed a sort of lacuna in the legislation, which means that this court cannot grant permission to apply for judicial review and sit as a judicial review court. So when the Upper Tribunal deals with a judicial review claim, refuses permission to apply for judicial review, there is an appeal to this court. This court cannot grant permission to apply for judicial review and sit as a judicial review court, as it could do if it was an appeal from the High Court refusing permission to apply for judicial review. You may want to look at NB Algeria.
NB Algeria.
Yeah.
That's not the best point, SSHD.
And NB Algeria. So there is a jurisdictional problem. And he then Lord Neuberger discussed various ideas that a single judge sits as a court of appeal and quashes the decision and then sort of reconstitute as in the first instance judge and then grants permission and then he said that all that would require amendments to the legislation. And
So the outcome of that procedural is that the right people have made the decision, but in the right tribunal, but under the wrong procedure.
Precisely, yeah. And the Upper Tribunal can sit for sure as an appeal tribunal and as a judicial review tribunal. They've done that in cases.
How about this, sir? If you're right, they could sit as a divisional court.
Yeah.
They could transfer the judicial review claim to the Upper Tribunal.
So sit as a judicial court, transfer the claim to the Upper Tribunal. Yeah. And then what happens?
Then they could sit as the Upper Tribunal. Because they're all judges of the tribunal.
What, rise to table?
everyone had an opportunity of reading it? You've had an opportunity of discussing it with your junior and your solicitor.
Absolutely.
Good.
So I'm not going to oppose the witness statement for obvious reasons. Indeed, I'm very grateful to DLD and to the defense for their efforts and for ensuring that this court is not misled as to what happened.
As are we. Thank you, Mr. Gullick, and those behind you for what must have required a lot of research and urgent drafting. Yes, Mr. Malik, ground two.
So ground two. Now, the court, of course, knows what happened. There was a decision.
Well, to some extent, we're better informed than we were, but I'm not sure we really know the full story yet.
So what I mean, the appellant makes an asylum claim. A person at the asylum Newcastle asylum team considers the asylum claim, takes the view that the appellant is credible in his account, takes the view that there is no sufficiency of protection, internal relocation is not an option, and says, see page 4 of the document, I have therefore decided to grant refugee status. I do ask you to highlight those words because they would be relevant. I have decided to grant refugee status and leave to remain for 5 years. So decided to grant are the words that appear in the biometric regulations. So this was a decision to grant refugee status, leave to remain. And the witness statement confirms that the BRP card and the letter was issued pursuant to this decision.
Yes, and somewhere in the witness statement refers to the 5-year expiry. I mean, this gets the date wrong of saying it's 2023, but 2028, 7th of August 2028 is what is said in the witness statement at paragraph 9.
Yes, indeed. So can I just quickly show you the BRP card and the accompanying letter? So it's not, I do emphasize that my case isn't simply about BRP card. It's about the letter that accompanied BRP card. Look at page 129 of the bundle.
So 149.
Sorry, 129.
Thank you.
The letters at 131.
Indeed, so 129 is the residence permit. And if you look at that document first, pursuant to the decision of 8th of August, this says that leave to remain until 31st of December 2024. But if you look at the letter,
It also says work permitted.
work permitted. So, I mean, this, as the First-Tier Tribunal said, this is a huge consequence. I mean, if you employ someone who has no right to work, you commit an offence. But I'll make those points shortly. If you look at the next page, page 130, you'll see the national insurance number, details relating to this parent. And then 131 is the letter. So this is the letter that the Secretary of State wrote. And she said that, second paragraph, that this is an important document. Look after it carefully. It is proof, this is the second paragraph, it is proof of your permission to enter and stay in the United Kingdom. You must show it at the UK borders when requested and may be required to demonstrate your permission to enter together with your passport. The BRP card can be used as a proof of your rights in the UK. You may be used as a form of identification, for example, bank accounts, etc. Then third, fourth, last paragraph that check the BRP, make sure the details are correct. But then if you look at the second column, it says that if the end date is displayed at 31st of December 2024, then don't worry. Don't contact us. That is not an error. question for the court is whether
Sorry, where does it say that in the second column?
second, sorry, if you look at the first column right at the end, and then it goes on to the
Oh,
next
yes,
one.
yes,
If
yes.
the expiry
Yeah, yeah.
date is 31st of December. So this was the date on which the BRP cards were replaced fully by e-visas. And you have evidence from the Secretary of State as to what happened with e-visa. So the short submission is that this VRP card, together with this letter, constitute a notice in writing by the Secretary of State that the appellant has been granted leave to remain. That is a submission that I say with the greatest of respect and diffidence, the court must accept, because there is an authority that is binding on this court that says so. And that is the judgment in the authorities bundle. At tab 12, tab 10. So judgment of this court in Ramphel, refugee, migrant, in Essex Forum, London, First Secretary of State. Now, I do ask you to note as to who is presiding. So the Vice President of the Civil Division, Lord Sunderhill, with in my submission unparalleled experience in immigration law. Lady Justice Elizabeth Lang, she deals with immigration cases in this court. Quite an experienced bench. So this is a case about about BRP cards and about electronic and written proof of residence. You've heard about Section 3C of the 1971 Act. The issue before the court was whether the Secretary of State was obliged to issue a proof of residence to those who are on Section 3C leave. And that was the context in which the issue was decided. That the paragraph that makes it absolutely clear what the law is paragraph 13 at page 142. May I ask you to read that paragraph? Leave to remain was previously governed by a sticker or a stamp on the passport, the courts would know. It was then replaced many years ago by a biometric residence permit, pursuant to the regulations. A BRP, the document that I've shown you, and or any letter accompanying its delivery, the letter that I've shown you, constitute notice in writing in accordance with Section 4.1 of the 1971 Act. A migrant who enjoys primary limited leave to remain can thus readily demonstrate their immigration status by simply producing their BRP. There is no way around it. You have, in order to dismiss my appeal, you have to say that Lord Justice Underhill got the law wrong. And Lady Justice Elizabeth Lang was wrong. Maleficent says in skeleton argument that this is wrong. And he needs to persuade you that it is. It isn't. Now, why is it that Maleficent says that it's...
Well, there's two different questions. I appreciate you rely upon this as an accurate statement of the law. Mr. Gullick, as you rightly say, submits in his skeleton argument it's wrong. And of course, you're entitled to point to the high persuasive authority of it. But you submitted earlier that it was binding, and that I'm less clear about.
So I do say it is binding. It is binding. It is part, in my submission, of the ratio of the decision. The documenting limited leave to remain was at the heart of that litigation. So it is binding on the court. But if malevolent is able to persuade you that it is not binding,
If it's binding, then
Yeah.
it doesn't matter whether it's
doesn't
right or
matter.
wrong. So it's quite important.
so I do say it's binding. It's part of the ratio of the decision. But if I'm wrong, and malevolent says that, well, it wasn't really an issue before the court as to whether BRP would or wouldn't constitute a notice in writing, then malevolent has to persuade you that it's not only arbiter, it is wrong.
Okay, well, just without deciding whether it's obvious or ratio, can I just look at paragraph 13 with you for a moment? So it starts off historically the record of the grant,
Yes.
all right? So that, to my initial reading, means that it having been granted, it is then recorded.
Yes.
And then at the last paragraph, a migrant who enjoys primary LLR can thus readily demonstrate their status by simply producing the BRP. So I'm just thinking that there is an argument that whether it's binding or not, that actually doesn't necessarily say quite what you say it says.
So if you read the first sentence and the last sentence, it doesn't say what I say it said.
But it's all part of the same paragraph.
But what about the second last sentence?
You rely on the penultimate sentence.
Yes.
But we've got to look at the totality of the paragraph. We can't just cherry pick one sentence. I can't pick the first and last, but neither can you pick the penultimate.
I get that. So the Secretary of State makes a decision to grant leave, which here I say is the 8th of August decision, and that evidence is then evidence, or a notice is issued by way of a sticker historically. But now there is it is notice in writing.
Sorry, I'm just. I'm just rereading 4.1.
So 4.1.
I'm just rereading section 4.1.
So grant of leave is pursuant. There is one further authority as to what 4.1 actually indicates. I'll
So Snickers Underhill set out in paragraph 12 of this decision what he thought were the material bits of 4.1. Do we need any more than that?
So this is Rumphel, and may I just show you one further authority and then explain why malevolent says it's wrong head on. And that authority may assist you on section 4. Actually, it's the judgment of this court in Anwar. You have that authority behind tab 16 of the bundle. And may I take you to page 246? If you look at paragraph 48.
48.
Yes, paragraph 48. So rather than sort of taking you to individual authorities that are referred to in this authority, I'll just take you to one authority where Lord Justice Singh essentially reconciles courts extensively from earlier case law. So paragraph 48, Lord Justice Singh quotes a paragraph from the judgment of Lord Dyson in Monet. Under section 3, the Secretary of State has a very broad power to grant leave to remain to anyone, even where the requirements of the rules are not met. Even where a person is not a refugee, even where a person is not entitled to leave to remain, the Secretary of State can say that, well, I grant you leave. But we now know that the Secretary of State took the view that this person was a refugee. And then if you look at paragraph 50, Amadi referred to all that in my skeleton, but the quote from Amadi is on next page, that the power to grant leave shall be exercised by notice in writing given to the person affected.
Where are you reading from now?
So yeah, this is page 247, the quotation at paragraph 50 between just against letter B. So this is a quote from the judgment of this court in Amadi. So a notice in writing is not a subsequent step to the following the exercise of the power. It is the way in which the power is exercised.
Yeah, and there's a rejection of the submission for the Secretary of State.
Yes.
The section 4.1 is to be read as if it said, and notice in writing shall be given to the person concerned of the exercise of the power.
Exactly. Yeah. So that was the submission the Secretary of State made, which was
Well, I mean, and Lord Justice Singh makes the point very clearly after section 4.1 doesn't really require written notice of the exercise of the relevant power to be given.
yes.
Rather, it is only by written notice that the power can be exercised at all.
Yes. Yes. No dispute about that. And if you then go to page 250 of the bundle, and look at paragraph 65, this will explain the basic purpose of section 4.1. Section 4.1 makes it clear that the notice in writing must be given to the person affected, and the purpose is to tell that individual that you have been granted leave, rather than telling the world at large. So this is the context in which you will consider the two BRP letters. And if you, there's some discussion, because there was a BRP issue in that case too. So if you go to page...
Sorry, can we just pick up 67 as well while we're here? Because he reiterates there that it is only through giving notice in writing that the decision is taken at all.
Yes. Yes. Indeed.
It is, if anything, even more emphatic than what he said at paragraph 50.
Yes. Yes. So notice in writing. And then paragraphs 84 and 86. This is about a BRP that was issued in that case. And the whole discussion, paragraph 86, is that the BRP did not set out the conditions attached to leave to remain. So the Secretary of State was saying that, well, I imposed conditions on this person's leave that he breached. The appellant's case was that, well, you need a notice in writing to impose those conditions. The Secretary of State's case was that, well, I've issued BRP. Lord Justice Singh is saying that, well, yes, you have issued BRP, but if one looks at BRP, that does not really set out the conditions. And therefore, no condition was attached. And the appeal was allowed on that basis. So this is Anwar and this is Ramphel. So why is it that Malevin says that Lord Underhill got the law wrong in Ramphel, and why this is wrong? Now, he cites two authorities that he says are the authorities for the proposition that a BRP card is not a plea when Lord Underhill was wrong. And the first of two authorities is behind tab 25. And you see that this is a decision that Malevin Friend wrote when he sat as Deputy Judge of the Upper Tribunal.
So he's convinced of its correctness.
Indeed. Marking is on homework, may say this respect. And the paragraph that Malevin cites, which indeed the Upper Tribunal cited, is paragraph 38. Malevin, the Upper Tribunal in that case said, well, BRP is evidence of a person's immigration status, but it does not in and of itself amount to the initial notification of the recording of status by the Secretary of State.
So this is an issue about Regulation 6.2D. So what does that say?
I'll take you to the regulations. That is.
Child benefit.
That is referred to at paragraph 37.
It's set out in paragraph 3. I'm just trying to get my head around it. So, as the lady says, this is about childcare.
Yeah.
It's the time within which claims must be paid.
So as far as I can tell, it turns on the date in which the claimant received notification that they were a refugee.
Indeed. I mean, this.
That's what it was all about.
Yeah, precisely. But I mean, if there are two ways to approach this. The first is that what is said at the end of paragraph 38 is directly inconsistent with Rumphel. And if the choice is whether to prefer Rumphel over this decision, the answer couldn't be clear. But then the second point is that what is being said here is that BRP is evidence of a person's immigration status, but it does not in and of itself amount to initial notification. But here we don't have BRP, only we have the letter. We have a letter by the Secretary of State given to the appellant saying that, well, this is a really important document. By this document, you demonstrate that you have been granted leave to remain. So if not BRP alone, then surely when read with the letter, that was a valid notice under Section 4, issued pursuant to the decision of 8th of August that the Secretary of State made in Dublin. You then go to the judgment in the second authority that Appellant cites, the judgment of this court in WA, tab 13.
Thank you.
An entirely different issue, and the judgment of Lord Sandhill isn't the main judgment. This is the third judgment, page 216. And there can be no doubt with respect that that paragraph is arbiter, but it does not undermine my case. All that is being said, just between letters F and G, is that the starting point, not the end point, the starting point is that the Biometric Residence Permit is a key document evidencing the right of residence and his status for all official purposes. It is equivalent in authority to his passport or his official identity card. Now that, on analysis, supports my case as opposed to undermining it. So I do ask you, of course, you will consider the authorities to just stand back and see how unattractive the argument is from the Secretary of State's perspective. She's saying that I have issued a BRP card, which she hasn't cancelled. She can cancel it, she hasn't cancelled.
Well, that's one of the problems in this case, because what the new witness statement says is the BRP was cancelled in November 2023, although I would believe, and you may now confirm this, that's the first you've heard of it.
Yeah, so it wasn't cancelled. You cannot cancel a BRP without issuing a notice in writing telling the person that I've cancelled your BRP, cancelled your leave. I mean, that wouldn't be. So if you don't have a decision cancelling.
All right, okay, sorry. You're, as usual, being very economical, and we are grateful for that, but these points need teasing out a little. So, can we just take it in stages?
Yes.
Stage 1, as I understand it, you would not merely accept but positively assert that the Secretary of State has power to cancel a BRP the appropriate steps are to take. Do
Yes.
I understand that correctly?
Yes. Yes.
So let me just make a note.
There is a bar under the regulations, but
Sorry, there's a power under the
there is
regulations
a bar
to
under
cancel.
regulations, but just
Sorry,
in,
all of this stuff is so familiar to you. You can't assume
yeah,
that
but
it's really familiar to us.
Yes.
So there's a power under the regulations to cancel a BRP.
But can I say this at once? Before we dig into that area, where the Secretary of State grants leave to remain, makes a decision, issues a passport, issues a BRP in error. It happens. What the Secretary of State can do is simply to withdraw that document. This court said that categorically in
Sorry. Again, I'm just trying to understand what you're saying.
yes.
You seem to be making a distinction between withdrawal and cancellation.
Indeed. So
And what's the difference?
cancellation part, you'll hear from Learned Friend. If Learned Friend says that this BRP card was cancelled, then it is for Learned Friend to explain where is the power to cancel it. There is a power to cancel under the regulations. If there is a cancellation decision, or had there been a cancellation decision under the regulations, we would have challenged it. But there is none.
Well, yes, but that's why I thought we need to break it down, because there's at least two questions which are different. One, well, in fact, three questions. One, is there a power at all?
Yeah.
Secondly, assuming there is a power, has it been exercised?
Yes.
And thirdly, if it has been exercised, has your client been given notice of the exercise of the power to enable you to challenge it?
The answer to all these three questions is no. And if Learned Friend says that the answer is yes, then he needs to persuade you that the answer is yes.
What we've got from the statement
Yes.
is in paragraph 6. The 21st of August BRP generated automatically. The error was identified on that same day, so 21st of August, same day the BRP was generated and cancelled on the Home Office system.
Yes.
One of the many things I don't quite follow
No.
is how then at paragraph 8 we're told that it was then manually cancelled on the Home Office systems when we're told at paragraph 6 it had already been cancelled on
I'll
the
take you to the
system.
regulations. Sure.
But that's a practical matter. That I just don't understand
No,
how if it had already happened.
I don't understand either. But before one looks at the regulations, the fundamental point is that you cannot make a decision to withdraw BRP or cancel it.
Sorry, withdraw or cancel. You
Withdraw-
told us there's a distinction
So
between
there
them.
is, and I will explain that distinction in a minute. But whether you withdraw or cancel, you cannot do so without notice. If you need an authority for that, that is Anwar Amadi judgment, the Anwar judgment that I've just taken you to. I mean, given that you have raised the point, can I just show you that judgment again, a part that deals more directly with this question, and I'll then take you to the regulations.
That would be
So
helpful.
tab 16 of the bundle. So I have shown you paragraph 50, which is at page 246 and 247, where by reference to where Lord Singh refers to the judgment of Lord Justice Sullivan in Amadi and rejects the submission that there's a distinction between grant of leave and notice in writing. So that is that. But then see paragraph 51, where there is this absolutely fundamental constitutional principle that you don't make internal decisions. You communicate those decisions with those who are affected. And that is not based on legislation. It's a fundamental constitutional principle that unless a decision is communicated, it's not a decision. So if there's a cancellation decision, Learned Friend needs to show you that decision and then prove that that was communicated. That is an impossible task because no such decision exists.
Right, so it's paragraph 52 summarises the point. The House of Lords held there be no relevant determination within the meaning of regulations because notice of it had not been given to the appellant.
Absolutely, and that is absolutely fundamental.
Reinforced by the constitutional principle requiring rule of law to be observed.
Even if there is cancellation decision, which there isn't, there's no dispute that it wasn't served, and therefore there is no cancellation decision. So finally, if I may just show you the regulations and show you the part of cancellation. The regulations are behind tab 2. These are biometric regulations. And the cancellation bar is in regulation 17. And you'll see that it is a confined bar. The Secretary of State only has the power to cancellation BRP if he thinks that one of these conditions apply. And none of those conditions apply here. And hence I say that if there was a cancellation decision, we would have challenged it on the basis that it's ultra vires. There's no suggestion that this appellant all gave false information, misleading information, or incomplete picture. It hasn't been lost or stolen, hasn't been altered, copied, failure to surrender, that doesn't apply. Holder has died, that isn't the case. Person has failed to collect the document, etc. So none of those provisions actually apply. So hence,
Right, so that's cancellation, but you explained to us a moment
Withdraw.
ago that the alternative was withdrawal.
so there is no power to withdraw under the legislation, right? But this court has said that there is an implicit,
Okay, where
there is
did we
an
get that?
implicit power under the legislation to withdraw a grant of leave. That is in error, and that is the judgment in YC China, tab 9 of the bundle. A remarkably similar case. YC applies for refugee status. Secretary of State sends a letter saying that, well, I'm granting you indefinite leave to remain. She then realizes that she has made an error, and then sends a letter saying that, well, sorry, I've made an error, and I'm not granting you indefinite leave to remain. And the appellant says that there is no power to withdraw a valid grant of leave. There is a power to revoke leave to remain under a different provision in the statute. There is a power to curtail leave to remain, cancel leave to remain, but no power to withdraw. Revocation of leave to remain applies where a person has obtained leave to remain by deception. Cancellation, there are immigration rules, so if you make false representations, if there is material change in the circumstances, leave may be curtailed, cancelled. And that none of that applies here, none of that applied there. So the Secretary of State came up with this ingenious argument that, well, there is no power, but if one looks at the statute as a whole, there is an incidental and power to withdraw leave. And that was based on the judgment of the Supreme Court in New London College, where
Is there a particular part of this decision you want us to look at?
I will
Just telling us what
show you where exactly it is at paragraph 80, page 132. So there is a power to grant leave. This must be exercised by notice in writing. There is a power to make a correction so as to ensure that a notice communicates the Secretary of State intended decision. And that is an incidental power under the Immigration Act 1971 read as a whole. And the correct position was notified to YC. And from that moment, he had no indefinite leave, he had limited leave. If the Secretary of State's case is that there was an error and grant of leave here was by mistake, then in principle it is open to her to withdraw. I show you this authority simply because you asked me a question. The Secretary of State isn't suggesting that she exercised a power in this case to withdraw the agreement. Indeed, there is a note from a learned friend dealing with this authority saying that it's not relevant, and I agree.
Can I just go back for a moment, sorry, to the biometric regulations as your second part of your tutorial, Mr. Malik.
Yes.
Looking at regulation 17 that you took us to,
Yes.
you explained to us that none of those apply in this case,
Yes.
and therefore there was, whatever it actually says in the statement that they call a cancellation, it was not in fact a cancellation because of the regulations. Could you just help me on this, just for completeness? On the 16th of November, forget what happened in August for a moment, 16th of November, the Home Office write the letter
Yes.
saying issued an error and asking for it to be returned. Now, would that letter fall within 17E of the regulation, please?
No, in my submission. So
Because
of two different reasons. The first is that 16E says that a person has failed to surrender the document when required to do so. So, assuming, Milady, that was a request to surrender the BRP, which I explained wasn't. If there was then a failure to surrender, the regulations then require the Secretary of State to make a decision. I required you to surrender your BRP. You haven't done so, and for that reason I'm cancelling it. That is the first point. The second point is that you'll see that refers back to Regulation 16. It says a person has failed to surrender the document when required to do so under Regulation 16. If you go back to 16, you'll see that the Secretary of State may require surrender if information provided was false, misleading, or incomplete, where the RP has been damaged or destroyed, and then you'll see a sort of a similar list. So none of that happened here.
Not E, the holder's leave to remain is to be cancelled or invalidated?
No, because leave to remain here has not been cancelled. In principle, it is open to the Secretary of State to cancel a person's leave. I don't dispute that. If there is a cancellation decision, a person feels that is an unjustified decision, the person will challenge it.
Understood.
But we are not at that stage, because the Secretary of State hasn't cancelled leave to remain. Her case is that I haven't even granted you leave to remain, so forget about cancelling. And this is what the First-Tier Tribunal faced. And the ultimate question, if one keeps these interesting legal points to one side, is whether there is an error of law in the First-Tier Tribunal's decision. As I've demonstrated by reference to the statute, section 11, right of appeal, if there is any, is on a point of law. And may I then just finally show you the First-Tier Tribunal's reasoning. And to essentially endorse those reasons. Go to page 95 of the bundle. Paragraph 24. Sorry, firstly, paragraph 23, the Secretary of State notes the November 2023. The First-Tier Tribunal notes that November 2023 letter, that there was a system error and that there is an apology. But the real point is at 24, that this is a document with serious consequences for the state. it declares to the world that this person has leave to remain. This is an integral part of maintenance of immigration control. And the Secretary of State's letter, milady, that you just referred, is inadequate in every respect by way of clarification. That is the first point. The Secretary of State has not supplied any evidence to explain how the error was made, BRP card was issued. The second point is that paragraph 25, that essentially the point that Lord Sandhill made, that there is a transition from stickers and stamps to BRP, and BRP is grant of leave. And then finally 26, that, well, why should the judiciary seek to do the Secretary of State's job? This is paragraph 26. In the middle, the Secretary of State has a range of powers available to her: cancellation of leave, revocation of leave, withdrawal of leave, so on and so forth. It is for the Secretary of State to make a formal decision to revoke or cancel leave. It is not within the power of the tribunal as a creator of statute to simply declare that an appropriately lawful act of the Secretary of State is null and void. But this is the submission that my friend makes before you, that this is apparently a lawful act, which she isn't taking back, but she's asking this court, as she asked the First-Tier Tribunal, to say that it's null and void, it had no effect. That leads to some very unattractive consequences. So if this court says in a decision that Secretary of State has issued a BRP saying that there is leave to remain, but it is null and void, I mean, what message I do ask this court to consider that sends out as to the reliability of these cards as a lawful proof of a person's immigration status? Secretary of State says, well, you use these to enter the country, use these to open a bank account and so on and so forth.
And to work. And to work.
Yes, the position, indeed, well, historically to work, but I must, of course, say that the position has now changed because of the transition to e-visas. So things are now done electronically, but indeed, so if you know, indeed to work. 27 BRP card is a valid leave, read with a letter in my submission. There is no decision to cancel or revoke. And Secretary of State might issue a decision to cancel or revoke if it's issued in error, but no such decision has been taken. No error of these are essentially findings of fact that the First-Tier Tribunal was entitled to make. And on the facts of this case, the tribunal was entitled to decide the matter in the way that it had. My apologies.
How does it sit? Sorry, how does that sit with the finding of fact in the first sentence of paragraph 26 that the Secretary of State didn't intend to issue him with the BRP, and he can have been in no doubt that she didn't intend to issue him?
Sorry, paragraph 26.
26 on page 96, the first sentence of that.
So the judge there, with respect, misled inadvertently by the facts as they were presented, took the view that the appellant had been in no doubt, that there was no intention by the Secretary of State to issue BRP. We now know for sure that there was initially an intention to grant leave to remain. Indeed, a decision was taken to grant leave to remain.
No, but he'd had the letter, so he personally, subjectively, he had no doubt.
No doubt. So,
But I think paragraph 26 almost reads like the judge is sort of thinking it through,
yes,
saying on the one hand, he must have known,
yes,
because he had the very detailed letter, which was unequivocal. But on the other hand, this is such an important document as to status and to policy that even if he should have known, even if he did know, as the judge found, that doesn't really matter, because without formal, proper
Notice.
cancellation, of which proper notice is given, he's still got the benefit of the document.
And just to answer the point that Lady just made, the Secretary of State's intention.
Fair, it's not my point, it's Mr. Gullick's point.
So the intention, whatever this, I mean, this is the point in Amadi and Anwar. What the Secretary of State intends is simply irrelevant. What is relevant is notice in writing. So if the Secretary of State intends to cancel a person's leave, there is no decision unless notice is given. If the Secretary of State intends to refuse leave but grants leave, it's the grant of leave that is the exercise of the power. And that is my submission. Just one final point, and then I conclude my submissions, is Melanchthon's reliance on Regulation 6 of the biometric regulations. My apologies.
Regulation 6.
Sorry, it's not 6.
13.
Regulation 13.
Okay.
Yes. So the reference says that, well, this is the enabling, the empowering provision. The Secretary of State may issue a BRP card, provided that the Secretary of State has decided to grant leave to remain. Now, why is it I respectfully invite you to consider that the legislations use the word has decided? Why not simply say, if Melanchthon decide, provided that the Secretary of State has granted leave to remain? So decided that there is a purpose. So the Secretary of State makes an internal decision that I have decided to grant leave, and then issues BRP. Hence, I showed you, when I showed you the internal decision, I asked you to highlight the words, I have therefore decided. So the Secretary of State made a decision. The Secretary of State decided on 8th of August to grant leave, and then by issuing BRP in the letter granted that leave. And that is the answer to Regulation 31. Unless I can assist you any further, these are my submissions.
Anything else? Anything else? Thank you very much indeed, Mr. Malik, most helpful. Yes, Mr. Gullick.
Well, ladies and lords, I'll deal with the grounds and the way in which we'll dealt with them. First, the jurisdictional point. I fear I may not be finished on that before a short journey, but I'll see how far I go. First of all, we submit that the Upper Tribunal, and the Melanchthon didn't take to the Upper Tribunal's decision, was right in its determination of the jurisdictional point. In particular, its analysis at paragraphs 23-26 and paragraphs 42-45 of its decision regarding what is a preliminary decision, and the fact that deciding something as a preliminary issue in terms of the point in the process at which it is decided does not mean that the resulting decision must be a preliminary decision for the purpose of the statutory scheme of excluded appeals. And to understand what is and what is not a first-tier tribunal decision that is appealable or not appealable, one needs to look at two things. First, the statutory scheme. And Malone and friends take me to the statutory scheme, but can I put down a marker in terms of that? The 2002 Act, the Nationality, Immigration and Asylum Act 2002, Malone and friends took to section 104A, and the references to final determination withdrawn, etc. within that. That is Malone and friends, I think, accepted eventually. That is not part of the Tribunal Courts Enforcement Act scheme, which applies generally to the tribunal system. The terms within section 104A of the 2002 Act are terms of art, as my Lord said, in particular withdrawn, and the deeming provision. So those are not necessarily to be read across. Well, they shouldn't be read across to the 2007 Act in the way that my friend suggested. He started off with the provision about deemed withdrawal of appeals.
Well, I didn't understand that to be his submission. I didn't understand him to be saying you could interpret Article 3M of the regulations by reference to different legislation altogether. As I understood it, his submission was, we look to the 2002 Act to understand the nature of the decision in question. And we see from that it is a decision that has been a deemed abandonment as opposed to a final determination. Understanding from that statutory context the nature of the decision in question, he then argues we can then see whether that falls into Article 3M or not.
Yes,
that's how I understood the argument, to be frank.
There we are. Well, if my own friend didn't make that point, then I've put down the marker in terms of the statutory schemes being different, and the statutory scheme which we're concerned with for jurisdictional purposes is the 2007 Act scheme and the order. But as my lord has just said, the First-Tier Tribunal in this case was determining whether it had power to deal with the substantive asylum appeal or whether the 2002 Act deemed it to have been abandoned. That was a jurisdictional question. Did it have power to go on to determine the asylum appeal or not? And to understand this question in terms of what is appealable from the first tier to the upper tribunal, one needs to look, we submit, at what we submit as a consistent chain of authority going back to at least 2009, which indicates, by way of headline, that the issue, for at least for present purposes, is whether the decision being appealed is of an intermediate character, to use language in some of the authorities, or is of a dispositive character. To use the vernacular slightly, perhaps I shouldn't say that the Court of Appeal used the vernacular in AA Iraq. Has the Upper Tribunal finished it? Sorry, the First-Tier Tribunal finished its task by reaching the decision which is sought to be appealed, and that applying that approach, decisions as to jurisdiction made by the first tier, including the present decision, are appealable. And this, we submit, is a consistent line of authority going back to 2009. Can I take you first of all to JH Zimbabwe, a decision of this court under the former statutory scheme, which governed the Asylum and Immigration Tribunal before the 2007 Act came in, but the statutory language is the same and it's been relied on subsequently. JH Zimbabwe is using the reverse order, it's tab 20, page 302. And this is where much of the jurisprudence starts in terms of the Upper Tribunal jurisprudence on jurisdictional issues. The court will see that's decision of Lord Justice Laws, Lord Justice Wall and Lord Justice Richards, who gave the leading judgment. And the you'll see the issue on page 304 at paragraph 2. Senior immigration judge, line 2 of paragraph 2 of his own motion, took a jurisdictional point. And you see the bottom of paragraph 2, you needn't trouble yourselves with perhaps the specific nature of the jurisdictional point, but the decision was expressed that JH had no right of appeal, promulgated on the 19th of September 2007. And you'll see that that was then sought to be appealed by JH to the Court of Appeal.
There's also a parallel application for judicial review.
Yes, but that was the basis on which the court was looking at that question. Could they hear the appeal against the SIJ's decision that there was no right of appeal to the tribunal? And you see the paragraph 4, the Secretary of State contended there was no right of appeal. And then if you look over the page at paragraphs 5 and 6, you'll see the procedure rules, and then you'll see the statutory provision in question, section 103A of the 2002 Act, which at that point set up or governed the system of asylum and immigration appeals. And if you look at the language in
Sub 7.
My lady's got there before me, subsection 7, reference to the tribunal's decision on an appeal, naming an appeal decision, does not include reference to a procedural, ancillary or preliminary decision. And you'll recall that those are the same words used in the order under the 2007 Act. And then you see the submissions to the Secretary of State. You see what the Secretary of State submits in the final sentence of paragraph 7. Policy arguments, Parliament must intend that tribunal decisions on procedural preliminary points will be final and not subject to appeal. And then you see that the ratio, the decision on this point in paragraph 8, where the you see that it had taken far beyond the Rule 9 stage. That's relating to Rule 9, paragraph 5 of the judgment in terms of accepting a notice of appeal. And then you see the crucial sentences about 8 lines down in the middle. It happens from time to time that the tribunal, on the determination of appeal or reconsideration, decides the tribunal lacks jurisdiction to entertain the appeal. I see no good reason of principle of policy why such a decision should be excluded from review or appeal. And in the unusual circumstance of that case, where it was the second time around point, it would be extraordinary if no right of appeal existed. So that was the decision then in JH Zimbabwe on the same statutory language.
Could you assist us? What's the reasoning here? I mean, there's a clear decision that a decision on jurisdiction is not excluded. Well, why not?
Well, as you see from the preceding sentence beginning, although the SIJ referred to Rule 9, it makes no sense to treat his decision as having been made under Rule 9 or as a procedural or preliminary decision of the kind referred to in section 103A7.
Well, yes, but I'm trying to obtain your assistance as to the thinking. So it's a very clear conclusion on the facts of the case. But I'm struggling to understand what the reasoning is. I mean, for example, I don't find expressed, and maybe you say would submit it's implicit, any definition of the word preliminary. So I'm trying to gain your assistance as to what we get out of this, other than the fact that it's a decision that on jurisdiction is not excluded.
Well, that was the finding, and that is what the Upper Tribunal found in the present case.
Right. So that's the limit of it.
Yeah.
Okay.
And it's then the foundation of the Upper Tribunal decisions upon which we rely. It's applied by the Upper Tribunal in a number of cases since then under the current statutory scheme. Take the first case, I think, was Abiat, which is at page 456 of the authorities bundle.
30.
30. I'm sorry, my lady. I've not got tabs in my bundle for reasons I won't take. And you see paragraph 8.
So I was wrong to say that this bundle was in reverse chronological.
I think-
Apologies.
I think
It's in random order.
I think it may well be, and those who prepared it.
Court of Appeal first, other
will-
decisions subsequently.
It's the Court of Appeal first in reverse order, then other tribunals in reverse order. I think. That's how I
Entirely
understood it.
random.
Okay, thank you.
Yes.
For my part, my sympathies go out to anyone that's trying to put these bundles together.
And you see, this is a decision of Mr. Oppleton, Vice President, and he sets out paragraph 8 onwards the relevant statutory provisions then applying under the 2007 Act and the Appeals Excluded Decisions Order. And then he says, paragraph 17, that the practice statements of relevant provisions about accepting notice of appeal adopted in the light of JH Zimbabwe, which I've just taken you. And then you see over the page, he sets out the judgment in JH Zimbabwe. And then you see paragraphs 20, 21 and 22. He discusses what he considers JH Zimbabwe decides. And you see in paragraph 21 the beginnings, perhaps, of the jurisprudence on the two senses of the word preliminary. Namely, is it preliminary in time or is it preliminary in terms of the issues? And you see in halfway down paragraph 21, preliminary for present purposes have two possible meanings. It may mean at the beginning or it may mean in relation to the possibility of commencing. And then you see the end of paragraph 21, Mr. Ogleton concludes, JH Zimbabwe essentially decides that a decision as to jurisdiction made after the tribunal has begun to consider an appeal, including a case where consideration is limited to the issue of whether there is jurisdiction, is not procedural and is not preliminary in the sense intended by the legislation governing the asylum and immigration tribunals. And then he goes on at paragraph 22, such an interpretation accords with what one would broadly expect. And then again, and you'll see this theme return to later on in the case law, halfway down the paragraph. But decisions taken on the way to arriving at determination of appeal are probably excluded from the appellate process because the latter's role is to entertain decisions against challenges against decisions which dispose of the appeal. Now, there are references replete. The case law is replete with references subsequently to dispositive decisions. And then you see over the page, paragraph 25, the finding in relation to that case. So in the present case, the First-Tier Tribunal did not issue a Rule 9 notice as its immediate and only response to the appellate notice of appeal. That's namely Rule 9 saying we're rejecting notice of appeal. It took jurisdiction to consider whether there was a right of appeal, and the decision it issues was not procedural because I've decided the decision to decline jurisdiction is not procedural and was not preliminary because, like the decision in JH Zimbabwe, it was not made at the very start. The First-Tier Tribunal's decision therefore carries the right of appeal to the Upper Tribunal. So that's applying this approach under the 2007 Act. There's other cases we refer to in our skeleton argument, also on the point. I won't take you to them now. There's the case of VED, which is at page 442 of the bundle. And if you'll note paragraph 6, the decision being on appeal being there was no valid appeal. Paragraphs 10 to 14, which say the decision was appealable and should have been expressed as an appealable decision. The next case I'll take you to is VOM, which my learned friend took you to from the Court of Appeal case law, but I just want to take you to what the Upper Tribunal found in VOM, as briefly as I can. It's at page 413 of the authorities bundle. I'm going to tell
Tab
my lady,
27.
tab 27. So VOM, importantly, was a case about error of law decisions and their appealability. So this was a case, as you see the judicial head note at 413, in a statutory appeal, the right to appeal in Section 30 of the 2007 Act does not arise to the Upper Tribunal to complete the process required by Section 12. So the issue in that case was, as you see at paragraph 3, whether a party to appeal proceedings to the Upper Tribunal has the right to apply permission to appeal to the Court of Appeal against the determination of the Upper Tribunal incorporating the twin elements of finding an error of law and setting such decision aside accordingly. So this was an error of law. What's sought to be pursued by way of appeal to this court was an error of law decision, which was then going to be followed by a remaking decision. And the Upper Tribunal says in VOM that one can't just appeal the error of law decision, one has to wait until the Upper Tribunal has finished its task by completing the statutory process required under the 2007 Act. And a few look, and I'll just, if I may, I'll just finish this point on this case. Paragraph, page 432, paragraph 23.
That would seem to be against you. If you can't appeal an error of law decision, and you have to wait until the remaking decision, that would rather tend to suggest that
This is the special nature of the area of law jurisdiction. The area of law jurisdiction was, as it were, on the way to the Upper Tribunal reaching its final decision on the appeal to it. Here, the First-Tier Tribunal has not reached an intermediate decision. If one looks at what the Upper Tribunal, the language the Upper Tribunal used, paragraph 24. The contention the appellant is entitled to seek permission to appeal to Court of Appeal in order to challenge this type of purely intermediate determination possesses, in our view, superficial attraction only. The fundamental question is whether Parliament intended an interim determination of this species should be challengeable on appeal at an interlocutory stage of the appeal process. And you see at 25, quite the contrary. We consider that the combination of principles and imperatives identified above impel overwhelmingly to the conclusion that Parliament cannot have intended to establish a right to seek permission to appeal to the Court of Appeal against an intermediate decision of this genre. This intermediate decision will ultimately merge with the final decision of the UT, thereby generating a composite decision. So there the Upper Tribunal is saying the error of law decision is on the way to the Upper Tribunal reaching its final conclusion on the appeal, and that is
Can
not
you help me on this? I mean, I'm struggling with all of this language about intermediate and composite when the statutory language is none of those things. It's procedural, ancillary, or preliminary.
Well, yes. The question is whether the decision sought to be appealed, which was an error of law decision, is an appealable decision.
Well, to be sure, but that one frames it in those terms, the inquiry becomes circular.
Have you finished with?
Yes, I think I'll finish with VOM, and then I'll go on to see how this court has dealt with VOM in the subsequent authorities.
Thank you.
As I say, I'll
We'll deal with that after the
deal
short.
with that too. Yes.
Very well. Thank you very much. 2:05, please.
Court rise